Welcome to Monthly Metz with Keith Metz.
Welcome to the Monthly Metz with Keith Metz, founder of the Metz Law Firm in North Carolina. Keith focuses on DWI traffic violations and misdemeanor criminal defense, helping people navigate charges that can affect their license, their record, and their future. I'm Lisa Mosbey, your host, and today we're talking about what happens if you refuse a breath test during a DWI investigation in North Carolina. Welcome, Keith. Thank you so much for joining me today.
Thank you, Lisa. This is one of my favorite topics to talk about, so I'm excited for this episode.
Great. Not something that other people really want to talk about, but we need to know about. What do most drivers get wrong about refusing a breath test in North Carolina?
I think there is a misconception, and I think other attorneys might agree with me. Some other attorneys might disagree with me, but I think there is a misconception about refusing the breath test. My clients that refuse learn to their detriment based off of some advice that they heard somewhere in some old wise tale that you should always refuse. The answer to whether you should or refuse depends on the situation, but I very rarely advise refusing. It makes the situation a whole lot more complicated. So I think it's it's usually better uh, to not refuse the breath test. Hindsight is sometimes 20/20, and so sometimes we can assess a case afterwards and look and go, oh, maybe you should have refused there, or maybe you shouldn't have refused. But I tend to find that in most of my cases where my client did refuse the breath test, it has made things so much more complicated for them.
And under North Carolina's implied consent laws, what happens immediately after someone refuses a breath test?
We got to talk about what happened, what's supposed to happen immediately, and what actually does happen. I do want to take a step back and also
Okay.
clarify uh, what is an implied consent law, because I don't think a lot of people know this. So implied consent laws basically they're applicable to more things than just DWI, but they are primarily DWI focused in the state of North Carolina. When you get your North Carolina driver's license and you sign in the back of that license, you are signing a contract with the state of North Carolina that says that you will not drive while impaired. And if an officer believes that you are driving while impaired, you are now essentially in breach of that contract. What this effectively means for you, other than the fact that you're being charged with the DWI, is that the officer does not have to Mirandize you. So I get this question all the time. The officer didn't read me my Miranda rights. Because DWI is an implied consent offense, the officer does not have to read you your rights. And there are other implications that come along with it from there, but that's the biggest one that I get all the time is not being Mirandized. Moving on to the other parts of your question, as far as what happens immediately, what is supposed to happen immediately is that your license will automatically be suspended for 1 year. That is what's supposed to happen immediately. That is not what happens immediately. Oftentimes, months will go by before your license is actually automatically suspended. Um, when you refuse the chemical breath test, the officer that's arresting you has to check off on certain very specific boxes on paperwork that gets sent to DMV. If the officer does not properly check off on a box, DMV will not enter the refusal. So sometimes some people get very, very lucky here in that they refused, but the officer maybe didn't do his or her job correctly. And as a result, the DMV is not going to enter the refusal. DMV is ultra technical. If one little thing is off, they will not do what they otherwise should be doing. And so if the officer doesn't check on a box, that's it. DMV is not going to enter the refusal. But if the officer does check everything correctly and submits everything to DMV, usually we say sometime within about 6 to 8 weeks, DMV will enter the refusal. And this is incredibly important to know because of the ability to get a limited driving privilege. So You might be charged with a DWI in January, but it might not be until March or April before your license is officially suspended. It is then suspended for 1 year, not because you've been convicted of a DWI, but because of the refusal. And you are not eligible for limited driving privilege during that time. So it means your license is suspended and you are unable to drive by any legal means. There are some ways to get around this, at least partly around it. But for instance, if you refuse and your license is suspended, let's say you beat the DWI. Let's say the DA agrees it's going to be dismissed, or you take the case to trial and you win and you beat the DWI, your license is still suspended because of the refusal, and you're still ineligible for limited driving privilege.
Is refusing a roadside breath test treated differently from refusing the official chemical test after arrest?
That is very different. Refusing the roadside is called a PBT, is what the officers refer to it as. It's preliminary breath test. You are absolutely allowed to refuse that if you want. Typically speaking, refusing it is going to mean that the officers are probably going to arrest you on the spot. But also, if you blow into that, it generally means the officers are going to arrest you anyway. So you can
Yeah.
refuse that with no ramifications. Your license is not going to be suspended. The refusal that counts is going to be what happens after they've arrested you and they've taken you to either the police station, um, or the hospital to get a blood draw. Blood draw is going to determine your BAC, the same as blowing into an intoxilizer at the police station will. If you refuse at the police station to blow into that intoxilizer, or you refuse at the hospital to have your blood drawn, then that is what's going to lead to that automatic suspension. But if you refuse the PBT roadside, that won't automatically suspend your license.
And Keith, how does a refusal affect someone's driver's license separate from the criminal DWI case itself?
Well, as I mentioned before, even if you beat that DWI, the refusal is still there and your license will still be
Okay, yeah.
suspended for a year. But this question does provide the opportunity to kind of explain why following and tracking the date on when and if the DMV enters the refusal is important, because um, you are not eligible for the limited driving privilege on a refusal, but you can become eligible for limited driving privilege on a DWI conviction. So sometimes, if the goal is to get you back on the road as soon as humanly possible, even if you have a good case to fight the DWI, sometimes it is better to simply plead guilty, because it allows you to get a limited driving privilege if you're eligible for one. Uh, Part of what we're looking at to determine when you become eligible is the timeline between when the refusal was entered and when we schedule your case to plead you guilty. At least 6 months must have passed. If you're even 1 day shy of 6 months, the DMV will deny the limited driving privilege. And I've actually had this happen before. I miscalculated once, and we were literally 1 day shy. When we pled my client guilty, we had to reopen the case. By the time we reopened the case and pled him, we were beyond the 6 month marker. So DMV takes this very, very seriously. You have to track exactly 6 months to the day to before you're eligible for the limited driving privilege. Since that event, this is many years ago, what I have done to correct this is I will track 6 months to the day and then add plus 2 days just to be on the safe side. But 6 months out from the date of the refusal, and this is important to remember, that the date of refusal is not the date that you were charged with the DWI. That is a different date from the refusal date, because the refusal date is when the DMV officially enters that refusal on your driving record.
And as you said, that can be weeks or months later. So it's important to know when. Keith, in refusal cases, what parts of the stop and arrest do you look most closely at when evaluating the case?
Well, I look at every part during the stop and arrest, even if it's a refusal case, because it's important. Because as I mentioned before, strategically, if the name of the game is just to get you back on the road as quickly as possible, then plea is always going to be their best bet. But sometimes it's not in my client's best interest to plead, even if they want to get back on the road as quickly as possible, because it does still mean you're going to have a DWI conviction on your record. And that comes along with a whole bunch of other ramifications. So regardless, it is still very important to review everything in the body camera and the dash camera to see what's going on in these cases, to make sure the officers, for instance, doing field sobriety tests correctly, to make sure my clients are doing well or sometimes poorly on these tests, to help determine whether their case is still going to be a good case to take before a trial. Um, because again, sometimes the name of the game is not to get back on the road as quickly as possible. Sometimes it is to beat the DWI. And sometimes my clients, maybe they work from home and they can live for a year without having a driver's license, but they don't want that DWI conviction. So regardless, it's important to talk about these things with your clients. I always do with my clients, to make sure that everyone's on the same page. We do understand what's going on, what our goals are, but I always like to review that body camera footage no matter what, to help enlighten all parties involved about what happened on that day or night when the DWI was charged.
I think I want to circle back again, and that is back to when you said that refusing a breath test can actually make it more difficult for the prosecution. That based on your experience, the things that you've seen is you don't believe that people should refuse that. Can you elaborate on that? Why is it more difficult for prosecution? What kinds of things do you run into?
So it depends on the circumstances. Sometimes it's more difficult for the prosecution. Usually it's more difficult for the defense. Um,
Okay.
but it varies. So we'll start with your question is towards the prosecution. Obviously, if there is a refusal, um, and there is no BAC, there is no evidence the state can use against you, no direct evidence of impairment that the state can use against you. They can still prosecute you, and they will still prosecute you based on your driving behavior, based on your speech, how you look, your balancing. They will still prosecute you based on how you do in field sobriety tests. But that refusal means that ultimate number, sort of the end all to be all, and whether or not you're impaired cannot be entered against you. So if you refuse, for instance, to blow at the police station at Intox, and the officer, for whatever reason, doesn't get a warrant to draw your blood, then that's good. You have officially kept out
Mhm.
your BAC results. They cannot come in and be used against you. All right. So that's help. That's helpful from a defense standpoint. But from a prosecutorial standpoint, there are other things. First of all, even if there isn't a warrant for your blood, the DA can still use the fact that you refuse as an argument as to your impairment. So the DA can show the judge, here's everything that he did poorly on the field sobriety test. Oh, and by the way, he refused. And they can essentially argue that the refusal, even though there's no official number that's spit out from that, the refusal in and of itself is an admission of guilt. That is what the state can and often does argue. Now, I've mentioned it twice here in the last minute, is what makes this incredibly difficult for your defense attorney and you is that if you refuse that intoxilizer at the police station, what usually happens is the officer can go get a warrant to draw your blood. And usually the warrants are given, and then you have a blood draw, which will still show your BAC. So the whole point of the refusal was to keep that BAC out of the state's hands, and they still get it. And now your license is suspended for a year because of the refusal. And it is for that reason that I typically advise against the refusal, because hindsight's 2020. Are there instances where officers don't go get a blood draw? Absolutely. But you're never going to know that in the instant. And usually they do go get a warrant. 9 times out of 10, they do. So the majority of the time, they go get that warrant, and then you still have a BAC from blood. And the 1 time out of 10 where they don't go get that warrant, you don't know that they're not going to go get it, and so it's hard to predict. So I generally recommend not refusing, if only because they can still go get it anyway. It can still be used against you. And now your license is suspended for a year.
Thank you for wrapping that all up and tying it in a nice bow for me to understand. Do you have an example of a case where somebody refused a breathalyzer test, and how quickly does that situation become complicated?
I'm working with a client currently, actually, who refused. And as I stated at the beginning of this, she refused because she was told you should always refuse these. And then she has learned to her detriment that the refusal has not been a good thing because her license is now suspended for a year. When she originally called during our client intake with her, she was frustrated because I couldn't give her a lot of answers to a lot of her questions. And the reason why I could not was because we got to wait for DMV to act. Goes back to your question at the beginning, right? Like, DMV is supposed to enter this refusal right away. That's what's supposed to happen. Is your license is supposed to be is supposed to be suspended immediately. And if that were the case, it would make tracking these sort of cases and being able to answer some of the more complicated questions that clients have once when they refuse a little bit easier. But the problem is we don't have a crystal ball, so we don't know when. First of all, we don't know if the DMV is going to enter that refusal, and we don't know when the DMV is going to enter that refusal. And as a result of that, what we typically have to do is have our clients, I usually say about every 4 weeks, pull an updated driving record. Um, Typically speaking, if the refusal has not been entered after 8 weeks, you're usually in the clear. I'm not going to say 100% of the time. I've seen it happen where 12 weeks later it's been entered. But usually, if the refusal is not entered within the first 8 weeks after you've been charged with that DWI, you're generally speaking in the clear. But that is 2 whole months where there's just a giant question mark on things. Is the refusal going to get entered? When is the refusal going to get entered? How long am I going to have to go on the suspended license? What's going to happen next? And there's a whole bunch of questions that we can't answer until we see until 8 weeks have passed and have seen that refusal entered. So this particular client, in her case, the refusal did get entered. It actually was entered within about 4 weeks, which is actually fairly timely for the DMV. But it was entered, and we were sort of able to answer those questions at that point in time and create a plan for her. She's got to drive for work. So in her instance, she's more on board with taking a plea. We have to track 6 months from that refusal date and then schedule that with the DA to plead her guilty. So this way we can get her a limited driving privilege. Ultimately, what that means is her license is suspended for 6 months and she's unable to drive during that period of time. And then 6 months and, like I said, plus 2 days, we plead her guilty. We walk into court and we plead her guilty and we get a limited driving privilege for her. Her license is going to be suspended for an additional year from that point in time because of the DWI conviction. But at least for that remaining 12 months, she has a limited driving privilege and she will be able to drive during certain hours to be able to get to and from work during that time.
I understand. Hmm. There is a workaround in some cases. Here's where I want to leave it today, Keith. How quickly should someone act after a refusal if they want to protect their license or challenge what happened during the stop?
You should act immediately. Ultimately, if this is a refusal, there's not much that can really be done here other than waiting it out to see when DMV is going to, if they are and when they are going to enter that refusal on your driving record, because that helps create a game plan for you. That being said, if you've refused, you have most definitely been charged with the DWI, which means you should absolutely lawyer up immediately.
Perfect. Thank you so much for your guidance on this. I'm guessing you're probably really good at puzzles because this seems like one giant puzzle. You have to take all the different pieces, and every single one of them is different. Every case is unique. Are you good at puzzles?
I never liked them when I was a kid, and so as a result, I haven't tried them much as an adult. Maybe I'd be good now, but I certainly wasn't when I was young.
Oh, yeah, you just have that mind for working these details out and following this train of thought, and, if I had you repeat yourself too many times, my apologies, but I am crystal clear now, and I appreciate your time today. Thank you so much, Keith.
Thank you, Lisa.
That's it for today's episode of the Monthly Metz. If you'd like to learn more about Keith Metz and his work at the Metz Law Firm, visit keithmetzlaw.com. Thank you so much for listening, and don't forget to subscribe, share, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.